Thank you for joining us today. I'll ask a few questions before opening up to the audience. So my first question is, from your experience as President of the Supreme Court, what do you think its role ought to be? Additionally, many people see human rights as one of the most regular issues to receive wider attention. What areas of law do you think the young Supreme Court has shaped the most?
Well, I think the function of the Supreme Court, and there's nothing very original about this, is to clarify the law when it's got into a bit of a mess, when there are disagreements in the courts below, to modernize the law when it needs modernizing, and I suppose in a similar way to develop the law when it's not so much a question of modernizing it but synthesizing it. And then occasionally you get what might be called big changes in the sense of human rights legislation in 1998 coming to force in 2000, when it's the duty of the court very much to lead and develop the law in an area which is hitherto unknown. And that was one of the most exciting things about being a judge during the period I was a judge, where in 1996, when I started, human rights wasn't part of our law at all. And then in 2000 it became part of our law. I was still a High Court judge. In the Chancery Division, I think I had 2 cases which mentioned human rights. Didn't have anything to do with them until I went to the Court of Appeal. And then in 2004 they were very much being developed. And the great hero, I think, was Lord Bingham, who was the senior law lord, who really took the flag of human rights and developed it in a very imaginative and brave way. I think that looking at it somewhat less conventionally, I think that one of the most important functions, in my view, of the Supreme Court in our present system is to uphold the rule of law at a time when people talk a lot about the rule of law and without sometimes understanding it fully and without following through its consequences. But I think at the present time, with instant communications, fast changing technology, the rule of law provides quite an anchor for what might otherwise be a slightly rudderless ship, to mix my metaphors a little. I think the Supreme Court has a very important role there. I think the Supreme Court also has an important role in the sense of acting as a somewhat unifying force in relation to the United Kingdom. We have what in some ways is a federal system, although we don't think of it as such, with England and Wales completely disproportionate size compared with Scotland and Northern Ireland having 3 different systems of government. And I think the Supreme Court has consciously to ensure a degree, on the one hand, of independence and autonomy for each of the 3 systems, but on the other hand, unifying. And one of the decisions it's got to make, which is one of the decisions I rather regret, is after my time, is whether the Northern Ireland law on abortion complies with the Human Rights Convention, which is very much of a topical issue. I think an aspect of the Supreme Court, technically not the Supreme Court, which is actually very important, is when the Supreme Court is sitting, which it does, I suppose, a quarter of the time, as the Judicial Committee of the Privy Council, hearing appeals from what you might call small islands in the Caribbean, Jersey, Guernsey, Mauritius, and so on, when actually it sounds a little bit colonial, but it's performing a particularly important function because those small places simply don't have enough people, enough lawyers, to have a Supreme Court. You can't have 5 judges in even somewhere the size of Jamaica, let alone the size of Mauritius, doing nothing but final appeals. And therefore, the Supreme Court, through the Privy Council, performs that function. And I think that's a very important rule of law function. Coming back to your question about important cases, of course human rights have been very important, and then public law has become very important. It's interesting that public law developed really in the 1960s. I haven't got the figures at my fingertips, but I think I'm right in saying in 1960 there were 140 or thereabouts judicial review cases in the year, whereas in 2015 I think there were 16,000. And so the public law, quite independently of human rights, has grown enormously. And I think in that connection, apart from ensuring criminal law is administered fairly and appropriately for the public interest and to protect the rights of criminals, and to ensure that private law is administered properly to ensure that people's disputes can be resolved fairly, the most important function of the Supreme Court and other courts is to hold the executive to account. And I think that that's got increasingly important, and to some extent the executive is, in theory, the weakest of the three branches of government. We all know Parliament comes top, we have parliamentary supremacy, the courts probably technically come second. We can tell, the judges can tell the executive what to do and what not to do in many cases. The executive can't tell Parliament what to do, or the judges. And yet in practice the executive is so enormous and so powerful with delegated legislation and delegated powers that I think part of the function of the court is to control the executive and inject, in some ways, a bit of spinefulness and a bit of guts into Parliament.
Thank you. As a
very long answer, sorry.
As a follow-up, you spoke about the need to accommodate big changes. Mm-hmm. And since your retirement, you have been helping to shape and understand the implications of Brexit on the UK's legal system. What do you think will be the major changes between the UK and the European Court of Justice approach? More generally, what do you think the judiciary in the UK is going to look like in a few years?
I have to be careful not to be too political. Judges get very cross when members of the government, or doesn't happen so much to civil service, and journalists speak out against judges in an inappropriate way. They should respect our turf. They can say they disagree with us, they can criticise our decisions, but they have to obey the rules. Similarly, the judges have to obey the rules and shouldn't start pontificating about politics. Now, you can say perfectly reasonably, I'm not a judge anymore, so I can say what I like. But I don't think life's quite like that. If I got up and said that I thought Brexit was a fantastic idea or a load of rubbish, the newspapers, who didn't like what I said, would immediately say, that's what all the judges think. David Neuberger can say it because he's retired, but actually it's what all the judges think. And they may say it'll affect their view of the Miller case or something like that. So I can't just say what I want to say too freely. Mm. But I can say, I think, that I find it surprising that almost 2 years since we voted to leave the EU, and 16 months into the 2 years since we served our notice, I really don't know, haven't got the foggiest idea what my answer is to your question, because our relationship with the CJEU will entirely depend on the deal, if there is one, or the absence of a deal, and the terms of the deal, if there is one, on which we leave the EU. For instance, if we remain in the single market, or if we remain in the customs union, or do something equivalent to that, it's quite difficult to see the EU agreeing that we won't have to abide by the decisions of the CJEU in relation to those particular institutions. And therefore the Supreme Court would presumably be in roughly the same position. But then you've got the question of, could the Supreme Court refer a case to the Court of Justice if we weren't members of the EU? So I think it's a big area. I was saying earlier in discussions that the difference between judges and lawyers on the one hand and journalists and to some extent politicians, although they're a bit in the middle, is that journalists inevitably, because they want to sell newspapers, because the public attention span is not necessarily very detailed, want to simplify the story and give the big picture. Lawyers are much more interested in fine detail and dealing with the particular facts of a particular case. I think politicians, particularly over Brexit, seem to have been drawn into the media's view of it. And so the fine detail, which is the sort of thing that worries lawyers, and I suspect a lot of civil servants, is something we have not merely no clarity about, but no idea where we're going. And so I don't really know the answer to your question. And to be fair to the government, even if they had got a clear policy, which they had announced, we don't know how much of it would be changed or junked as a result of discussions with the EU. So I'm afraid it's an even worse answer than the last one I gave, because I'm telling you I don't know the answer.
Absolutely, thank you. So many people have criticized the lack of diversity in the Supreme Court, and in the past you've said it's a much wider problem, a much deeper problem. With Baroness Hale as the current president, do you think this marks a new era for gender equality in the legal system? And what steps do you think are still necessary to improve diversity more generally?
In defence of the judges, well, let me start off. The most obvious discrepancy, or possibly the two most obvious discrepancies, are in terms of gender and ethnic mixed BAME representation in the senior judiciary. I mean, if you look at the tribunal judiciary and the circuit judiciary, it's better. But the higher up you go, on the whole, the worse it gets. I think, in fairness to the judiciary, I would say that when it comes to women, the High Court judges are almost exclusively selected from the top of the bar, a bit few from the solicitors. If you look at the number of QCs who are women, I regret to say it's about 13%, which, when you bear in mind that the intake into the bar, about 45% of women, it's quite shocking. And I used to think it could be explained by the fact that the QCs represented the intake 25 years earlier or 20 years earlier. But I don't think that will really do anymore, because I think the intake of women to men has been about the same now at the beginning. So you have this enormous drop-off of women. And it's the same with solicitors. If you look at the top firms, about 13% of the partners are women. So the fact that 20% or 25% of the High Court are now women suggests that, in that sense, we're not doing too badly. But 25% is not what it should be. It should be around 50%. What should we do about it? Well, there are two extreme options. One is to encourage women to apply, to do what I did and a lot of other judges did. If you've got a woman QC in front of you, and indeed a male QC in front of you who you think would be a really good judge and you know hasn't applied or believe hasn't applied, then you ask them to come and see you and say, you know, have you thought about this and would you like to? And I would support you. The other extreme, which is more coercive, is to have a quota system, which I'm personally not in favour of. But I see the argument. Some people say that there's a middle way of targets, but I have a suspicion that targets quickly turn into quotas. With ethnic minorities, I think, with BAME, I think there is also a problem. It's a bit harder to identify what it is, but the proportion of BAME judges in the senior judiciary is pathetic. There are none in the Supreme Court, one in the Court of Appeal, and I think two in the High Court, which, if you think there are 110 High Court judges, about 38 Court of Appeal judges, it's not good. Women, I mean, to be fair, Baroness Hale was the first woman ever to get to the top court, and there are now two there. And I suspect it won't be long before there are three. But that's still only a quarter. So I think steps of the sort I've mentioned about approaching people who are promising but possibly too modest to apply or haven't thought of applying is the least we can do. And the other thing, which I've always banged on about, which is easy to talk about, difficult to know what to do about, is subconscious bias. I think there is this, and I'm sure I suffer from it, and I see it in other people on selection panels. And unconscious bias training is worth doing, but I still remember all the judges were asked to go on unconscious bias training, and of the 12 members of the Supreme Court, 11 went. I won't tell you who didn't. But the first thing that we were asked on the course was to list our own subconscious biases. And I put up my hand and said I wasn't quite sure. Well, surely the whole problem was you didn't know what your own subconscious biases were. Wouldn't it be better if we listed what we thought our colleagues' subconscious biases were? But anyway, it is a problem. And training, having sort of joked about it, training does help, but it's not the complete answer. your generation should be doing better than we did. And to be fair, my generation's done better than the previous generation, but it's taken a lot longer than expected. My wife's making a series, doing a series of 100 interviews to celebrate the, she was a television producer before, to celebrate the fact that it'll be 100 years next year since women were allowed to practice law. And she's identified that the first 50 years, hardly anything happened. And the next 30 years were very slow and hard to believe now when I've given you those figures. It's definitely got a bit better, but the past 10 years have shown less progress than the previous 10 years. So it's over to you guys.
Thank you. So as a follow-up question, the process of selecting justices for the Supreme Court in the US and in the UK are very different.
Yes.
With the US being much more public following an appointment made by the executive branch and voted upon by Congress. You've said in the past that it leads to choices that are more based on political views rather than experience or abilities as a judge. Mm-hmm. What are your thoughts on the different selection processes and which one do you prefer?
Well, I think that the trouble with comparing the system is that American judges, because they have a constitutional role, they're able to strike down legislation. They're able to, it is they who decide what the gun laws should be within reason. It's they who decide within reason whether you can have abortions and so on. They do have more of a political function than judges in the UK. Now, it's fair to say that since the Human Rights Act, judges here have become, if you like, more political or policy orientated in their functions. But it seems to me that we have in the United States a much more polarized Supreme Court. A Supreme Court where judges are more likely to be rude about each other, which I don't think is good for the law or for the reputation of the court or for the internal harmony of the court. And that, I think, is all part of the fact that they're politically selected and so on. Now, to be fair, in Germany, the Constitutional Court members are selected politically, but it's done in a much more amicable way. When one judge who was appointed by the Social Democrats, for instance, the SPD, stands down, the SPD come up with an alternative and a replacement, and it's discussed in a friendly way in the Bundestag, and they agree, either everyone agrees that he's not really suitable or agree that she is suitable, and she gets appointed. So I think you can have a political input, but one of the problems is in general, to say something works in one country, therefore let's do it here, is not always safe. It's a bit like trying to change a plant, to take a plant which is doing very well in one garden and assume it'll do well in your garden. It won't necessarily work. I think our system is okay. I mean, the old system where you had the Lord Chancellor effectively selecting had the enormous advantage of speed. If you had the Lord Chief Justice or the President of the Supreme Court going, the Lord Chancellor could say X will take over that job, Y will take over X's job, Z will take over, and so on. It would all be done after discussing and so on. But it depended on the quality of the Lord Chancellor. Would he, because it always was a he, would he consult, would he be sensible? Did he know what was going on? The last two old-style Lord Chancellors we had, Lord Mackay, Conservative, and Lord Irvine, Labour, were both very, very good at doing that. But it all depended on who the Prime Minister appointed as Lord Chancellor. The present system is much more clunky with committees and so on. On the whole, I think it does well. But it's more effort, more time, more money. It's a difficult one, but I think the old system, you couldn't go back to the old system even if you wanted to.
So when the idea of creating the UK Supreme Court was first introduced, you said that, quote, it's very good for some reasons, but I'm worried about certain things, end quote. What were those concerns, and do you think they materialized?
Yeah, I got teased about this because I was a law lord when the law lords were going to be transferred to the Supreme Court. And Joshua Rosenberg, the legal journalist, did a program about the change, and he spoke to 5 law lords, including me, about the change. And my 4 colleagues, more cannily than me, just said how wonderful it was and how excellent and so on. And I was a bit more honest, and, well, I think a bit more honest, and said it was good for a number of reasons. It gave the Supreme Court a clearer identity. It gave the public a clearer idea of what we were, who knew what the law lords were, whereas the Supreme Court is, to use that tired expression, says what it does on the tin. The Supreme Court could run its own show. We could enable people to come and see us much more easily than the law lords, and it just gave us a bit more confidence and identity. That was the good side. There were 2 bad sides, I thought. One was the cost. The legal system, the court system, is starved of cash. It's worse now than it was when the Supreme Court was formed. And I just felt that this was a great deal of money. The law lords cost nothing. They were already peers being paid for by the House of Lords. They used 1 or 2 employees of the House of Lords. They sat in committee room in the House of Lords. Their overheads were very small, whereas the overheads of the Supreme Court are many millions. And I just regretted the fact that a lot of money was being spent on the Supreme Court out of a court budget which was already starved of cash. And I stick to that view. I think I was right to be concerned, but probably it was a very short-term view, but I still think there was real force in it. The second reason I was concerned was that I thought it might make the judges too uppity. I thought that if we were put into a court of our own, called the Supreme Court, and so on, it might make the judges start becoming too political and too keen to exercise power. I don't think it did have that result, but I would say that, wouldn't I? Others may judge, but I think on the whole, I think human rights have given the judges much more power than the creation of the Supreme Court.
Absolutely. So my final question before we open up to the audience, what would you have done differently if you could have your 5 years as President of the Supreme Court back?
It sounds rather arrogant to say I'm not sure I'd have done a great deal. I'd have decided 3 or 4 cases differently from how I decided them. And I'm not going to tell you what they are. It's an interesting point, actually. I've broken this rule myself, but on the whole, I don't think judges, whether they're retired or not, should talk about their judgments should talk about their judgments very circumspectly. Because if, let's say, in one case I've said X, and then later on to you or publicly I say, actually, I think I was wrong, what is a Court of Appeal or High Court judge to do? Somebody quotes the judgment saying, so what Lord Neuberger said, you must follow it, it's the Supreme Court. And the opponent gets up and says, yes, he may have said that when he was in the Supreme Court, but 2 years later he tells an audience he thought he was talking a load of rubbish and really wishes he hadn't said it. It's not, you've just got to bite your lip and accept that you don't get everything right and that hope that it will be put right. So I think it's specific decisions. I think maybe I should have been a bit firmer about discouraging too many concurring judgments. I don't mind dissenting judgments at all, but concurring judgments are a problem because if I say I agree with Lady X and add a few words of my own, unless I'm saying I don't agree with her on this or want to expand on a new point, often the concurring judgment says roughly the same thing in different words. And apart from being very unfair on all of you, because you've got to read so much more, and apart from many more forests being pulled down in order to produce the paper for it to be printed on, it also makes the law a bit less clear, because I may think I'm saying the same thing as Lady X, who I'm agreeing with, but because I'm not parroting her words, I'll be saying something slightly different. And clever lawyers later on will say, actually, there was a difference between the two, and we don't quite know what the law is. So I think I should have been a bit better about reducing the number of concurring judgments. Having said that, I mean, I did try and reduce them, and I think on the whole it went a bit up and down, but I think on the whole I did reduce the number of concurring judgments. It may be if I'd pushed harder for it, there'd have been more of a pushback against me, but I think I should have done that. I wish I'd spent a bit more time going into my colleagues' room, talking to them. I think they felt I was better than some people might have been at that, but I could have done more of it. And I think I should have spent more time a bit more time with some of the staff who were not. Inevitably, you had staff in the court who you saw regularly, the communications people, PR, whatever you like to call them, and the people who did the lists and that sort of thing. You saw them regularly. But there are a lot of people who did important work who probably I should have spent a bit more time seeing. So rather boring, no big things. I only wish there's only one case that I would like to have overturned. And I'm not sure I would have done if the opportunity had arisen. But I would love to have overturned Pepper and Hart. The number of cases we got where counsel had to look, and solicitors had to look at what was said in Hansard about the legislation because they were frightened if they didn't and something was said that they would be negligent, and then felt because they were charging their clients a lot of money for having looked at it, they had to quote it to us, were legion, and it never made any difference. And I accept in theory there'll be one or two cases where it could make a difference, but one has to look at this not too absolutely in a overall way, and I do think that we lost out. I do think that the one or two very, very rare cases where Pepper and Hart may make a difference are totally disproportionate to the enormous expense and time taken up in looking at Pepper and Hart material. So I would like to overturn Pepper and Hart. Having said that, I can think of one or two of my former colleagues who would have been breast high with me on that, but I think there are one or two who would have been fighting to keep Pepper and Hart. So maybe it's just as well I didn't have the opportunity to have a go. But I don't know what you think about Pepper and Hart. Those are lawyers here, but I think it was a backward step.
All right, thank you. So now we'll take questions from the audience. If you'd like to ask a question, please raise your hand and wait for the microphone to reach you. And please stand up and project your voice. So the first question will go to the ex-president.
And please don't be embarrassed about asking any question. I always say there's no such thing as an inappropriate question, only inappropriate answers. And no doubt you hope I'll give them, but I'll try not to.
Stand up so everyone can hear me. I was once lucky enough to attend a talk from another Supreme Court judge, who I won't name, and he alluded to, in this rather smaller talk than this one, about the sort of political bias within the Supreme Court. And evidenced his point by listing off quite a few cases where some judges were in the majority and two were repeatedly dissenting or the other way around to show how there was political bias. And I was wondering what your explanation for those cases might be. And also with regards to just sort of that political bias in general, I think I'm right in saying that the President of the Supreme Court chooses which judges sit each cases. Given that you probably have personal relationships with most of the Supreme Court judges, did their sort of political affiliation or possible political affiliation ever play into your decision on who would sit in which case? Thanks.
It's a very good question. There is no doubt that when it comes to some issues, there are judges who have different predilections, different inclinations. When it comes to the role of the executive in making decisions, all judges would agree that the judiciary have a duty to ensure that the executive doesn't get the law wrong, doesn't trample on minority views, etc., doesn't exceed its functions. But I think some judges' inclination is more towards saying, and I think I should add that most judges, I hope all judges, would accept that they should respect the executive views in the sense that they should say the primary decision maker is the executive. We are reviewing the decision ultimately, not making it afresh, although with human rights it's a slightly more nuanced issue. But I think there is a definite difference between different judges, and I think anyone who studied the Supreme Court will know who I mean. I mean, I did divide my colleagues into four categories. Those who tended to be more inclined who were more prepared to disagree with government decisions, overturn government decisions. Those who were more inclined to uphold government decisions. Those who were fairly centre compared with the other two groups, and those who were completely unpredictable. And I don't want to exaggerate it. You can go through the cases, you certainly can go through the cases and identify a large number where the usual suspects, as it were either against the government or for the government. But there are a number where there are unexpected alliances and defections and so on.
Which group did you put yourself in?
Well, that's an interesting question. I put myself, I would say, if you call the people who wanted to kick the government left wing and the people who wanted to uphold the government right wing, I saw myself as inside right. But when I talked to our judicial assistants I raised it with them for 3 years. The court has judicial assistants, they're like law clerks, if you like, acting for the judges. And I did discuss with our judicial assistants, 3 years lot of judicial assistants, and majority of them thought I was inside left. So you pay your money, it takes your choice. I think I'm reasonably central. And I think it's probably easier in some ways, if the president is reasonably central. But I think that the difficult point you identify, and in many ways the most difficult part of my role as President of the Supreme Court, was the point you've mentioned, which is picking judges to hear cases. And the difficulty was this, that on the whole, the court was more conservative than more right than left. Not much, but if you looked at the panel. So the question is, should I have ensured that the majority was always more right than left, or should I have ensured that the panel was fairly balanced? And what I did was to make sure, because I knew that my colleagues would be looking at it, and I knew that the outside world, those people who were interested in it, would be looking at it. And I was quite anxious to ensure that I had a balanced court. So I would tend to have, if I had two radical, two left, I would have two right and one centre. If I had one left, I've had one right and three centre. Sometimes it didn't quite work out like that. But on the whole, one thing I did not want to do was to pack a court to produce a particular result, because that way madness lies. And if you start doing that, of course, it undermines the whole system. But the Germans, for example, with their history of Nazi governments in the 30s, and then the East German Stasi type government in the 50s, 60s, 70s, and 80s, are shocked at the idea that somebody picks the judges to hear the case. They think it's completely inappropriate. And, for instance, the Constitutional Court in Germany, they select there are two panels, and they select them by ballot. And when you have different judges who might hear cases in lower courts, it's all done by ballot. It can be tricky. And it isn't just on political things. I mean, for instance, a topic which I think judges, particularly me, have spoken far too much about, interpretation of contracts. There's no doubt that there are some who are more inclined to rely on the words more than the commercial realities, and others who place more weight on the commercial realities. And that, again, is slightly a temperament thing. It's not a political thing. And there again, particularly when going after different people had expressed slightly different views, when choosing a panel to hear the Capita Wood and Capita case, I was quite careful to try and have a balanced court. Similarly, on illegality, on the question of whether you should have whether there should be a valid right for malicious prosecution in the civil context, where different judges had expressed views, I was very careful to have a balanced court and try and have one or three swing votes who hadn't spoken on the topic before. Because, as I say, just picking up a bit further, you also had some high-profile cases where everybody wanted to be on it, and you couldn't have all 11. So you had to make sure that each of your colleagues had a fair dollop of boring cases and a fair dollop of exciting cases. And one of the reasons in Miller that I had 11 was not merely because it was a very important case. but also because I didn't really relish saying to two of my colleagues, or possibly four, sorry, you're not on Miller. But that helped ensure we had 11. Also, I was worried that we might be split as we were, and if we didn't have 11 and we were split 5-4 or 4-3, newspapers that didn't like our result would have said if only they'd had all of them sitting, it would have gone the other way. So that was the other reason for having 11.
Thank you. Next question, we'll go to the hand all the way in the back.
Hello. Nowadays, we see more use of technology in the law, for instance, with like doc review or automated forms or things like that. Do you think we'll ever get to a point where robots or computers could ever replace judges, or do you think judges always need a sort of moral, human element in their judgment?
I doubt that I'm any more able than anyone else to predict that. My own view is that at some point, whether it's 20 years or 2,000 years, we will be able, I'm afraid, I don't like it, but we will be able to have a machine doing the job that a judge does. I'm not religious. I believe that everything up here is either chemical or electrical, and it may take a lot of time, but we will be able to reproduce it and do better than it, in my view. And therefore, yes, I think we will end up with machines. Whether we have a machine to act as a first instance judge and 3 machines to act as a court of appeal, with one of them programmed to dissent periodically, etc., I don't know. But I think in the long term, I think what one would call a pessimist. I think in the end, we will get machines that can do everything we can do. But as I say, it's not a topic on which I can pretend to particular expertise, but it's a fascinating question.
Thank you. Next question, we'll go to the second row.
There seems to be an increasing reluctance on the part of the Supreme Court to decide important cases or depart from important historic cases without a larger panel. So in your judgment in the KU case, you said that the court shouldn't reconsider Wednesbury without a panel of 9 judges. Obviously, Miller, there were 11 judges sitting. And a couple of weeks ago, the judgment in Rock and MWB refused to examine the issue of consideration and the rule in Folks and Beer without the aid of a larger panel. And so I have really 2 questions that follow from that observation. Firstly, is it not disingenuous for the judges to use that as an excuse when it's within the court's discretion to decide how many judges should sit on the panel? And secondly, is there not a danger that with more judges sitting on fewer cases, fewer appeals get heard and the backlog of cases increases?
Another very good question. I think often, and I have no idea about the position in the MWB case because it was very recent, I wasn't on it. Often when a point doesn't need to be decided and the court says we're not going to decide it, it often is because they're divided on the point. And if you've got 5 judges out of 12 on an important point, which they don't have to decide and which they're not agreed on, it's better not to decide it. If all 5 were agreed on it, then there's a high, and again, they may have been agreed on it in the MWB case, or they may have felt that they hadn't had it fully argued to their satisfaction. That's another possibility. Sometimes you feel it has been properly argued, and we are all agreed, but actually we'd like to think about it a bit more. That may be an abdication of responsibility, but one of the great law lords, Lord Wilberforce, when he was asked, question you asked me, have you any regrets? He said, yes, I regret any time that I decided a point that I didn't strictly need to decide. I was quite keen on deciding points I didn't need to decide, particularly when I was a more junior judge, to sort of slightly show off, I fear, looking back on it. But I think that there's a lot to be said for only deciding what you need to decide, because the chances are that you may sometimes make a mistake, so why risk it? The view the other way is entirely the view you've given, which is if it's there costs a lot to get to the Supreme Court, takes a lot of effort. The point's been argued, surely it should be decided. And your point that if you're going to have 7 or 9 all the time, then the backlog's going to get greater, is right. But I think the answer is to that the Supreme Court, and it was, again, may factor into a question I was asked earlier, do I have any regrets? I think it may be right to say that the Supreme Court perhaps takes rather more cases than it should. I think there are, and certainly in my time, there were cases that didn't raise any great points of principle. But nonetheless, either because we felt the Court of Appeal had got it wrong or because we were interested in the point, we took it. But whether the world was a better place for it, I'm not sure.
Thank you. Next question, we will go to the hand just in front, just over there.
It's just a simple question for me, but obviously your judicial career has seen many interesting cases. Just out of personal preference, what was your favourite case?
In a purely self-glorifying way, my favourite case, I think I had 2 favourite cases. One is Pye and Graham, which I decided as a first instance judge. And it was a strange case. A property development company had brought up a couple of large fields, and wasn't going to be able to develop for many years. So they gave a farmer a license over it for a short time to put his cows. The license expired, and 13 years later, when they were about ready to develop it, the property company was faced with a claim by the farmer's widow, because the farmer had died, unfortunately, for a claim for adverse possession, that they got title by adverse possession. The law's now changed. And I held that she had got title by adverse possession. I felt it was very unfair. I felt the law was antiquated in relation to registered land, because there was no need to have this law when you knew who the owner was, because it was registered title. So in rather a, some might say, characteristically lengthy judgment, I said that I regret to say this, I regret to come to this conclusion in these days of human rights, but I think the property company has lost this land to the farmer's widow. A number of friends of mine said to me, David, only you could express regret at finding in favour of a widow against the property company. But the case then went to the Court of Appeal, and they said I'd got the facts wrong and I'd got the law wrong, and the property company won. So given that this was my area of law when I was at the bar, I felt A, pretty cross, and B, pretty small. But the case went to the Supreme Court, or then the House of Lords, and they said I'd got it all completely right, even to the extent of regretting the decision. So, of course, I like that case. Another case I like, which for a similar sort of reason, was a torture case. In the Court of Appeal, the issue was, could a court decide a case by reference to evidence obtained by torture? There were lots of other issues in the case. And I said no, and my 2 colleagues said yes. And it went to the Supreme Court, and or then the law lords, and they agreed with me. So that was another sort of happy case. But more seriously, my 2 favourite cases, I think, were in the Supreme Court. One was a case close to my heart to do with nuisance, called Fen Tigers. And I'd always been, or Coventry and Lawrence, it goes under various names, but it raised some interesting points on the law of nuisance that I'd always been interested in. And I really enjoyed writing the judgment. And the other case has to be Miller, because it was unique in terms of public perception, in terms of the mass febrile atmosphere, or some might say hysterical atmosphere, the newspaper coverage, the fact that there were 11 of us, the fact that I was very anxious that the majority produce one judgment, and there was a lot of email traffic over Christmas trying to get my 7 colleagues to agree on one judgment. So I think that's probably the answer to your question. But there are a lot of other cases I really enjoyed. Felt very lucky.
Thank you. Next question, we'll go to the second row.
Shortly after the Miller case, Liz Truss, then Lord Chancellor, was criticised reportedly for not adequately defending the judiciary. Do you think it's problematic to have a politician who is, on the one hand, responsible for defending the interests of the judiciary, but may also have political concerns and reasons for politically avoiding doing so adequately?
Well, I could uncharacteristically answer that question with one word, which is yes. I do think that's problematic. Our old system had its disadvantages, but at least there was somebody in the House of Lords who therefore, whatever you think about the House of Lords, at least couldn't be kicked out of Parliament, who was not primarily a politician and therefore was not interested in political games, and who was at the end of their career rather than the beginning and therefore not interested in promotion. So that was undoubtedly, and you had somebody who the Prime Minister always sensibly chose, who really knew about lawyers, the legal system, the rule of law, how the courts worked and so on. And with Liz Truss, she ticked none of those boxes. She knew nothing about the rule of law, nothing about the way judges and the system works. She'd been a politician, she'd not been a lawyer. And I felt slightly sorry for her, although she failed lamentably to step up to the mark. I have to say that I felt actually, I'm sorry to say this, but I felt actually the real culprit was the Prime Minister, who was a very experienced politician who'd been Home Secretary for 6 years and who knew just what the score was. Now, I have a lot of sympathy for politicians. They have a very difficult life, all sorts of things to balance. And, unlike a judge who simply says, I've got to decide this according to the law. But I do think that the Prime Minister should have stepped up to the plate on that one, and not, to be fair to Liz Truss, she should not have effectively prevented Liz Truss from stepping up to the plate. I think Liz Truss looked to Downing Street for guidance, which she shouldn't have done, and she got the wrong guidance and she followed it, which she shouldn't have done. But to be fair, although they failed lamentably when it came to the divisional court decision, the enemies of the people headline, I like to think that both the politicians and the media, or those parts of the media that had been hysterical over the divisional court decision, had learnt their lesson a bit when it came to the Supreme Court decision. They behaved much better. But to be fair, the atmosphere had calmed down a bit. It didn't come out of left field. They had 3 dissenting judges who they could have as heroes. So it's a little difficult to know what to make of it, but it was a very bad moment, yes.
Thank
and
you.
it does call the present system into question. It's fair to say the last 2 Lord Chancellors, David Lidington, who was there for a very short time and wasn't a lawyer, but had done research as his doctorate into the Court of Exchequer in the reign of Queen Elizabeth I, so he probably knew more about that than any judge or lawyer in the country. And the present Lord Chancellor, who's also a lawyer, are a bit more tuned to what they should be doing. And I think lessons were learned, and I hope long-term learned.
Thank you. Next question will go to the hand just there in the light blue shirt.
We have already addressed today that there are still problems with diversity. Does that mean that it is fair to say that the higher ranks of the judiciary are still unfit and still not aligned properly to ordinary life?
In a sense, it's inevitable that the judges are going to be unaligned with ordinary life. There's a limit to how far you can push realistically for a wholly representative judiciary. I mean, logically, you're not going to ask for a serious criminal judge or a judge who's not particularly intelligent. You don't want a purely representative judiciary. But more seriously, one of the problems we have in this country is that the senior judges are all chosen from experienced lawyers. And that immediately narrows the field. And when I was talking about diversity, I didn't mention what is, to my mind, by far the most serious problem, a long-term problem in relation to diversity, which is background, social, economic background. And in that sense, the judiciary particularly the senior judiciary, are woefully inadequate. And that is partly a problem of legal recruitment to the the solicitors and chambers, but fundamentally it's a comment on our society in which we live. So you can perfectly fairly say, yes, to a significant extent, the judges are out of touch. They tend to be taken from a relatively small and relatively privileged group. Most of them, I'm afraid, privileged from birth, but almost all of them privileged from the world they managed to get into. I think to some extent that's inevitable, because on the whole, you probably want your judges to have been successful in their life in the law, and therefore they will be, quote, out of touch in the sense you use it. But I think it's particularly important if you have got that A, we try and ensure as a society and as a profession and as a judiciary that we do encourage people and enable people from less privileged backgrounds to become lawyers and work their way up and to become judges. And secondly, that those of us who come from privileged backgrounds do our best to identify, to acknowledge that we aren't in touch, as it were, with ordinary people. We haven't led ordinary lives, haven't suffered the deprivations that most people suffer. And A, try and acknowledge that and get in touch with it, and B, actually go out and see what goes on and talk to people. Now, if you're a busy lawyer or a busy judge, it's an easy thing to say, but it's difficult to do, but it's something which I think we should all do. I mean, I have started, thanks to a young man called Amar Khan, who was at Exeter University. His father was an immigrant from Pakistan, taxi driver in Dudley in the Midlands. He approached me out of the blue when I was President of the Supreme Court and said I should be visiting state schools, underprivileged schools, going to universities and colleges and so on, talking to people, and I've done a bit of that. And he and I have started encouraging all lawyers to visit at least one state school a year. It's not a big deal, and in a way, the fact that you have to do it is a sign of the rightness of what you're saying, but it's a start. But it's a perfectly fair point you make.
Thank you. We have time for 2 or 3 more questions, so we'll go to the hand just behind.
Thank you so much for being here. I used to study at Harvard Law School, so my question is actually, what is the biggest difference do you see between the U.S. Supreme Court and the UK Supreme Court? Because what we learned at Harvard is most likely about the American judiciary system and also the Supreme Court. Thank you.
I think that's a very good question. I haven't studied the US Supreme Court that closely. I mean, I'm aware of it. We've had 1 or 2 exchanges, but on the whole, I wasn't party to them. I've been party to other exchanges. I would say the differences the obvious major difference is that in a system of parliamentary supremacy, which we have, our judges in this country cannot undermine, cut down or challenge primary legislation passed by Parliament. Whereas in the US Supreme Court has a duty to cut down legislation, however unanimous and clearly passed it was, if in their view it doesn't comply with the Constitution. And that probably, in a way, is the biggest difference. It has a knock-on effect that I think that the earlier question, the first question that was put to me, touched on the political predilections of the judges in this country, which undoubtedly do exist in what I hope is a mild but nonetheless definite way. In the US, there seems to be a stronger political affiliation for obvious reasons. The way they're selected is more raucous and more political. Third difference, the way the work is distributed is very different. We, in the Supreme Court here, we don't decide who's going to write the judgment till we've heard the case, discussed the case, and then the senior judge who chaired the panel will decide which judge will write the judgment. In the United States, the work is parceled out in advance on an equal basis. Fourth difference, They sit always in bank, all 9 of them sit. Again, it ties in with the question I was asked, whereas the only time we've sat in bank, all 11 of us, because we were missing one judge, was in the Miller case. Otherwise, we always sit 5, sometimes 7, occasionally 9. I think until recently, one would say that it was quite common, very common, for the US Supreme Court judges, having said that they tend to be rude to each other. I think now Justice Scalia has died, there's probably less rudeness around, but they are more direct about each other. But on the other hand, until recently at any rate, they were more likely to join together in writing judgments. Until recently, a joint judgment in our Supreme Court was very rare. Under my time, they weren't enormously numerous, but there were many more joint judgments on which judges colluded, partly to make up for the fact that I was discouraging concurring judgments, so judges had fewer judgments to write. So the way of accommodating them and keeping them happy was to enable them to write judgments together. Didn't always work, but it was quite good. It helped. I'm sure there are other differences. Yes, of course, an enormous difference. Their hearings are very short. I mean, in America, in the United States, plenty of appeals, not to the Supreme Court, but to federal appeal courts, often take place without a hearing. The court will decide the appeal in writing. That would be unheard of in this country. And then in the United States Supreme Court, I believe, I may be corrected, that it's almost invariable that you get no more than half an hour to argue your case. And for most of that time, you're not able to develop your arguments. You're fielding questions from the judges, who are actually trying to convince their colleagues by the questions they ask that they're right. In our system, it's not unknown for an appeal to last 4 days. It's very unusual. The average appeal lasts 1 or 2 days. Now, I think half an hour each side is much too short. Doesn't really enable the oral argument to get going. But to be fair, I think in many of our cases we're a bit indulgent in the Supreme Court. Similarly, in our Court of Appeal, we could actually have shorter hearings. But I very often have changed my mind, sometimes more than once, as a result of the oral hearing, asking questions, listening to the points. I think it would be a tragedy if we followed the American system, and indeed most other systems, in having such short hearings. But I do think we could have slightly shorter hearings in many cases than we do. Those are the differences that spring to mind.
Thank you. Now, one final question will be in the 5th row.
This question's a little bit left field, but it's a matter of personal interest to me, although you might not be able to answer it briefly in just a spoken answer. We've currently been having quite a few fiery debates in tutorials over the particular nature of tort law, and much to the dismay of my tutor, I've been holding quite a hardline instrumentalist view. And I was just wondering what you thought the aim of tort law was, whether it was more of an interpersonal justice matter or an issue of social control.
The 2 areas of law which you start off with, or when I was starting off as doing law 50 years ago, which you thought of as being the obvious areas of private law, were tort and contract. And from my view, and it's not quite an answer to your question, as I've gone through nearly 50 years, 45 years as a lawyer and judge, they seem polar opposites. Contract remains subject to clear principles and rules, not always clear and sometimes changing, but it's relatively rule-based. More and more convinced that tort, or at least negligence, duty of care, that area of tort, is pure policy. It's dressed up as subject to rules, but in the end it seems to me to be, because I say so, this seems, it's all given away really by the Caparo test, which the courts have sort of gone in and out of. But the ultimate question, is it fair, just and reasonable that this person should be liable? Well, you know, that is not law, that's just policy. Now, what drives the policy, which is really what you're saying, I think. I think I don't think there is a perfect answer. The common law is if I want to be kind, I would say that it's pragmatic and practical, and to quote Oliver Wendell Holmes, it's based on experience rather than logic. And therefore to pin it down on whether it's there to protect people or for the benefit of society as a whole, instrumentalist and so on, is not, I think that's more of a, if you like, a civilian law view of life, more philosophical, more French than English. We approach it in a pragmatic way. I mean, the case we moderately recently had about whether the police should be liable in tort for turning up, totally cocking up and turning up late, as a result of which, on being called by a woman who said she was about to be murdered, as a result of which she was murdered when she might have been saved. That was, if you like, policy, and it was simply that it seemed wrong to hold the police liable for this. But you could argue it was a curious decision. In fact, I think that Lady Hale and Lord Kerr, who may just be in one of the categories mentioned in the first question, were of the view that it was inconsistent with the approach of human rights, and they were entirely right. If you could bring the case within Article 2, then the policy argument about not holding the police liable went out of the window. I think it was also an example, to pick up another question, of the court saying this is the principle laid down in, I think it was Hill and the Chief Constable. Can't remember what it was, but it was laid down in a case in the 1980s. And we simply continued to apply it. I don't think that continuing to apply a principle laid down 30 years ago is necessarily cowardly. It is quite important that you change, that the common law, well, it's quite important that the law is predictable and clear. You're very conscious of this, and all judges should be conscious of this when they have a case where the law seems to point in favour of a decision which is unfair on the particular facts. Some judges then cheat on the law to get a fair result, which makes them feel very good and they've achieved justice. But A, they'll probably be reversed in the Court of Appeal, so the person they've helped is going to lose anyway and pay 2 lots of costs rather than 1. But more importantly, you're mucking up the law for everybody else. And I think there's a slightly different point, but I think you change the law. This is why I'd call myself inside right rather than inside left, I think. You should change the law very, very diffidently, because A, you don't quite know what the effect of the change is going to be. Easy to see what's wrong with the present system, but as we all know with change, it's not always easy to see what unfortunate results it has. But you're also suddenly creating uncertainty. So you have to be very sure that it's right to change the law before you change it. And don't misunderstand me, there are times when it's obviously right to change the law. But tort is a particularly tricky area because the society changes quite quickly, technologically, socially, morally, politically. It's quite difficult to know when something's a short-term change that does require the law to move on. Which is why I think judges quite like the is it fair, just and reasonable, because then you can just adjust what's fair, just and reasonable to the mores of the particular time. But you do leave the law in a state of uncertainty. And I think the way Lord Toulson put it in a couple of judgments was, yes, we have got this very broad test, but just look at the individual cases in which we apply that test, and you can discern on a case-by-case basis some sort of micro principles. But I suspect that the judges in a common law way aren't looking at the stars like you do in terms of great principles of instrumentalism and so on. They're looking at the ground and looking at rather more basic questions of does it seem sensible in this case, bearing in mind the previous cases. That's the way the common law has tended to proceed.
Thank you. Unfortunately, that's all we have time for today. Please join me in thanking Lord Neuberger for joining us today.